Hi, my name is Jane Meadus, and welcome to the Elder Law Town Hall series on empowering older adults through knowledge. Today, I'm going to be speaking about long-term care homes and admission and the legal issues with respect to them. I'm the institutional advocate and one of the staff lawyers at ACE, we are going to be recording this, and it will be put up onto our YouTube page in a few days. And the slides will also be posted to our website. There will be a lot of information today, so certainly be aware that you will be getting access to the slides after this is finished. I'd like to start today with the land acknowledgement. We commemorate the Indigenous people's principal kinship to the land, the fact that they have not and cannot be erased from her, our collective First Mother. We acknowledge that we, particularly the ACE offices in Toronto, sit on the traditional territories of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties signed with multiple Mississaugas and the Chippewa bands. So first, I'd like just to say that this is legal information and not legal advice, and that if you wish to get legal advice, you would have to contact a lawyer. At the end, there will be time for questions, so please put the questions into the question box, and those will be monitored and will be read aloud at the end of the session. So the Advocacy Center for the Elderly is a community legal clinic established in 1984. We have 6 lawyers, 3 paralegals, and an administrative coordinator. And our mission is to uphold the rights of low-income seniors and improve the quality of life of seniors by providing legal services, which include direct client assistance, public legal education, law reform, community development, and community organizing. So prior to the pandemic, hospital discharge to long-term care was probably our #1 call. From between 2012 and 2017, it went from 250 calls to about 700, and we're probably more than that now. It still is probably our #1 call at the moment. We find that patients and families aren't being provided with the correct information. They're being misled, especially if the person is in the hospital. And this creates distrust and slows the process down. Many of you would be familiar with the LIN or the CCAC. That is now called Home and Community Care. It's the HCCSS. It will probably morph into something shortly once the new Ontario Health Teams and Ontario Health takes over. But at the moment, it's the HCCSS, but you can think of it as the LIN. So I'm going to be talking about admission today, and admission is a very complex area, and I'm going to be talking about all the things that you have to do, as well as some of the things that you need to look at and be aware of in case you run into problems. So you have to understand that applications can be made from either the community or hospital. They're made through the HCCSS and not through the hospital. So even though you might be in a hospital dealing with a discharge planner, you still need to speak with the HCCSS, and that's the placement coordinator. Anyone can apply for long-term care. There are some minimum requirements, obviously, but you don't need anyone's permission. And you need to be ready to go to long-term care when you apply. So don't think, well, I'm going to put my name down now and then sometime in the future I'll go, because you never know what the waiting lists are. So you need to be able to go, whether it's in hospital. So if you've broken your hip and you've just had surgery, you probably can't apply until you've recovered from that and are stable and ready to go. The Long-Term Care Homes Act and the Healthcare Consent Act govern the admission and the choice process. So those are the laws that govern admission. And many, hospitals might have policies around what they say are their process for applying for long-term care, but those policies cannot override what the law is. And again, as I said, it's the HCCSS that is responsible for admission and not hospitals, who sometimes try to override the process. So the placement coordinator is responsible for compiling the application, determining eligibility, assisting the person in making choices, sending the applications to the chosen long-term care homes, and making the bed offers. They cannot refuse to take an application. They cannot advise you that the application can only be made after a discharge from hospital, or only from the community, or only from a retirement home. They can discuss things like returning with home care and provide you with all your options. They can talk to you about alternatives to long-term care. But those, if you're eligible for long-term care, you have to determine whether or not those are appropriate, and whether or not if you're eligible, whether or not some of those other things are appropriate. So if you're in hospital specifically, and a lot of what we'll talk about today is applications from hospital, because that's where more of the problems occur, you know, that you can't be forced to go to some of these alternatives. Criteria for eligibility. So you do have to be 18 years old in order to apply for long-term care. You have to have health insurance under Ontario's Health Insurance Act. There is an exemption for that. What you have to require is 24-hour on-site nursing. That does not mean a nurse at your bedside 24 hours a day, just access to it. Need assistance with activities of daily living at frequent intervals, on site supervision or monitoring. You have to have sort of gone through all publicly funded community-based services. So any kind of services like through the HCCSS, through home care, and other kinds of publicly funded services are no longer suitable or enough to take care of you. And your care and requirements can be met in a long-term care home. No one can be required. So it's some information you need to know is that no one can be required to care for an adult if they do not wish or cannot provide that care. So the exemption to the OHIP is that if you're applying from another province, which Ontario does allow you to do, you can make the application, and when your bed offer is made and when you arrive in Ontario, you are automatically given OHIP. So you have to apply, but you will be given it for that day. However, if you're in a federal interim health benefits program, you are not allowed to apply for long-term care, because federal interim health benefits are not the same, and you do not qualify for OHIP. Sponsored immigrants with no income can apply, but can be admitted to a long-term care home, and the home can't charge back to the sponsor. However, ODSP will be applied for. You can apply for it, the resident can apply for it, and the home could apply for it on their behalf, and that will be charged back to the sponsor. So issues around sponsored immigrants in long-term care is kind of complicated. Another issue is that there's no upper limit set in policy or in law by the government for care. So a person can be made eligible for admission to a long-term care home, despite the fact that really their needs can't be met in the long-term care home. And the problem is that the hospitals and the government have not kept up with the requirements for, say, chronic care. There's a closure or repurposing of a lot of chronic care facilities in Ontario, and other places that might be able to provide services such as psychiatric facilities don't want to take people long-term either. So when you apply for long-term care, certain assessments will be done, and those are physical and mental. They determine the requirements for your health care, what kind of functional abilities you have, what kind of personal care assistance you require, current behavior during the previous year, and any other information or assessments that are required under the regulations. One of the documents that will be completed is called the RIMDS for long-term care. And that will be done by the placement coordinator, where they enter information into a computer, and information will be obtained from the applicant, from their family, medical sources. That generates a score to determine, your level of care required, which will allow the placement coordinator to determine whether you're eligible for long-term care. And you can request a copy of that document to ensure the information is correct. You know, it's only as good as the information input. And so we often, if there's any concerns, you know, suggest that people have a look at that so that they can make sure that the information is correct. So during the pandemic, there are some exemptions around people making applications that you don't have to actually apply. So they can be started sort of through the hospital. You only have to consent to the release of the information. And because of the limitations during the pandemic and difficulty getting information, they don't always have to comply with all of those assessment requirements. You can be admitted on, you know, fewer of those things. They try to get as much as they can, but they are exempt from complying at the moment. The placement coordinator has to provide information at the time of the determination about the process. So when they're talking to you, they have to tell you about the process for being admitted to long-term care, the kinds of choices around facilities that you have, and the implication of those choices. So for example, lengthy waiting lists, you know, short waiting lists. So they have to give you that information so that you can make informed decisions. So they do have to provide you information about, you know, alternative services that might be available to you, the charges and your responsibility to pay charges once you go into long-term care, any rate reductions that might be available to you, and what the applications are. Approximate length of waiting lists for the homes. They do have them. Some post those, some do not. Some of the HCCSSs post them on their websites and some do not. And they're probably not that helpful these days because most people are going in as crisis anyway. If there's any vacancies in homes, they will tell you that. How to obtain information, including compliance reports from the Ministry of Long-Term Care. And compliance reports are available for all homes and all compliance reports since 2010. And all you have to do is to Google long-term care home reports Ontario, and you will find them. And if the first is incapable, they should be telling the substitute decision maker about how decisions are to be made by the substitute. So you don't just get to make any decisions. You have to either comply with known wishes of that resident, of the incapable person, or if they didn't have any known wishes, you would be making the decision with respect to their best interest, and the LIN should, or the CCSS should be telling you about that. So it's really important for an application to be taken, even if HCCSS says, oh, you know, they're not going to be eligible. So if you really feel that you want to go to long-term care and you think you should be eligible, you should make that application, because findings of ineligibility are appealable to the Health Services Appeal and Review Board. And but you have to actually have made an application and have an actual determination of ineligibility before you can make that application. So even if they say, no, we don't think you're eligible, or you're not going to be eligible, if you really want to go there, you can certainly, you should be demanding that they make that application. If you're determined ineligible, then the HCCSS must suggest alternatives and make appropriate referrals. And they also have to provide you in writing that they have determined that you're ineligible, the reasons for their determination, and your right to review, apply to the HR for a review of that determination. So if you are appealing, unlike home care, you don't have to use an internal complaint process first. You do have to appeal in writing to HSARB. The law says that the hearing has to commence within 20 days after they receive the application, and they have to give you 7 days notice. Usually they will ask to have that extended, and usually that makes sense. And in every ineligibility case that I've ever been aware of, there is always a pre-hearing conference to try to resolve the issues And for the most part, I think they are resolved at those pre-hearing conferences. Usually what happens is that the assessment will be redone to make sure that all the information was collected and input properly. And very often they will change their mind prior to the any hearing, and the person will be made eligible. But if it goes ahead, there will be a formal hearing. At that time, HR can either affirm the decision of ineligibility, rescind it and send it back to the HCCSS for directions to redo it or what have you. Or they can substitute its own determination of eligibility. They have to give their decision within 1 day and written reasons within 7 days, and those can be appealed to divisional court. I'm not aware of any cases that have actually been appealed to divisional court, but there certainly are cases reported that you can see and read about where people have been found ineligible and they've gone to the board. So, once you are eligible, then you get to determine which homes you want to apply to. The person will make that determination. And if they're not capable, the substitute will do it on their behalf. Obviously, even if you're capable, you may not be able to go out and see them. We do recommend, if possible, that someone goes to see the homes for you. It is a little trickier during the pandemic. Some homes have restarted their tours, but it may be a little bit more difficult. It is hard to tell, for example, on a video tour what a home really looks like. The HCCSS will assist the applicant in choosing homes if they want that. And if they're helping them, they're going to take into consideration, their preferences based on ethnic, religious, spiritual, linguistic, familial, and cultural factors, closeness to family, that sort of thing, when they're recommending homes to a person. And an application for homes can only be made with the consent of the applicant. And so sometimes what we get is hospitals or Lynn saying, well, bed is available in, Shady Acres, and it's not a home that you've ever applied to. And that is not a bed offer. So bed offers are only ones that are applied to in either by the person, and there's an exemption for pandemic, but basically that has to be a home there's been an actual application to. Applicants can choose any home in any part of the province of Ontario. If you are applying outside of the area where your HCCSS is, you are going to be the application will be sent to that other area, and then they will forward it on to the home. One thing that sometimes confuses people is if they are living in one HCCSS area, but then they're in a hospital in another one. You always apply where you are at that point. So if you've been admitted to a hospital, so for example, if you were in, you live in Newmarket, but you had to have surgery at St. Mike's in Toronto, you are going to be, and that's where you're going to, where you are when you are applying to long-term care, it is going to go through the HCCSS office for Toronto, and that person will be in the hospital. You wouldn't be doing it through your home where you may have been getting home care. So the HCCSS does control the admission process. And when it comes to choices, you of course have to have a minimum of one. Generally, it's a maximum of 5 homes unless you're in crisis. If you're in crisis, you can choose more, but you're not required to. You can still choose one. The number of choices that you make, the types of home are not relevant to being made a crisis. Neither the hospital or the HCCS have authority to make you choose specific homes, and there is a pandemic exception to that. They can't require you to, for example, choose semi-private or private because those have shorter waiting lists. They can invite you to do things, but they cannot require you to do things. So they can't say you must choose 5. They might suggest it. And we obviously, given long waiting lists in long-term care homes, we suggest that people choose as many homes as they want, as they can, because it's definitely an issue with respect to the number of beds that are available in long-term care. So application issues, as you may know, there's between 35 and 40,000 people waiting on waiting lists. And so when you're in hospital, you know, the hospital wants you to get out. And so they are going to be making suggestions about things and trying to get you to make many choices and things like that. And so, you know, there's certainly issues that arise, and some of them that certainly that we see have to do with numbers of facilities, different policies that they might have. And as I said earlier, the hospital can't have policies around the number of facilities you choose or short lists or anything like that. But we certainly do recommend that people consider those things, because if the only home you put on a list is a 10-year waiting list, it really is not appropriate to be sitting in a hospital for 10 years in most cases. And, you know, if you say, well, you know, I only want to go to that home because it has a certain ethnic or linguistic you know, bent to it. The hospital doesn't have that either. So, you know, does it make sense to stay in a hospital? And we actually don't recommend staying in hospital very long, because they do not do long-term care very well. It is not what they do. They do acute care. And so if you're in a hospital bed, we get a lot of complaints about people who are waiting for long-term care and saying, well, we're not getting any services. They're not, you know, we're not getting showers twice a week and all of that. And so there's a lot of things that you may miss. And so we certainly do recommend people to consider homes that might have shorter waiting lists so they can wait for their top priority in a long-term care home. So some of the application issues that we run into are, for example, people being asked to apply for preferred accommodation because they may, and preferred is like semi-private or private, and those may have shorter waiting lists. And they're often told that after 1 year you be transferred, and that's not true. You can apply for transfer on the day that you arrive at the home. Sometimes homes will tell you have to wait a year to apply, and that's not true. So you can apply on the day you arrive home to transfer from, say, a private room to basic accommodation, but you will have to pay for that room until a bed comes available. And we've certainly had people wait many, many years, like 7 years, for a basic accommodation to come up. So you have to be prepared to pay all that time. So if you're not, you should not be applying for preferred accommodation. Another issue we sometimes run into is the home may try to income test a resident. They may ask information about income. That information may be provided by the HCCSS. We don't think they should be providing that information, but it certainly happens. In fact, homes, because it's not anything to do with eligibility, so ability to pay is not part of eligibility. So they're not actually entitled to that information. Only time you have to provide information about income is once you're admitted. If you're in basic accommodation and apply for a rate reduction, that's the only time when you might be required to, that is the only time you are required to provide income information. So this is only up until December 14th, so another couple of weeks. But right now, if you're in a hospital and applying to long-term care, and you're going from the hospital into long-term care, if you go into a facility that is not your first choice, the Ministry of Long-Term Care will pay your accommodation fee until such time as you're admitted to the home of first choice, or you're offered a bed in your home of first choice and refuse to go. So right now, if you or someone that you, a family member of yours is in hospital, this is an important thing to know, is that in the next 2 weeks, if you are admitted into a facility that is not your first choice, you actually don't have to pay until you're transferred. And so that is a really, might be a real important thing for people, and it would save money that you may be able to use for other kinds of care, maybe some assistance in the home. So consent for home choices. So applications can be only be made by the person, and person can only be put on a waiting list with the informed consent of that person or their substitute decision maker. The exceptions are in a crisis is defined under the Healthcare Consent Act, and that's not being put on a crisis list. What that means is, say, there's an incapable person in the community, they're found, their house is unlivable, they can't get in touch with anyone to make a decision on their behalf immediately, and so they could be placed in a home without consent. I've seen it happen, I think once many years ago. Generally those people, because there's no beds available, they're usually going into a hospital and then they get placed with substitute decision making. But it is possible to do an admission without consent of an incapable person or a person in a very serious immediate situation. And it can happen. Also, for example, it could happen in cases where a long-term care home burns down, it has a fire. So people are displaced immediately, and it may not be possible to get informed consent of everyone to move them to another home. And that would be another situation where that could happen. The other is right now during pandemic, the HCCSS coordinator can actually put choices on a list for you that you are not, that you do not want. I actually haven't seen it yet, but it is possible. And they have to obviously take into consideration all of the things that, you know, are important to the person, but you can be placed in homes in areas that you don't want to live because of severe pressure on hospitals during the pandemic. Hospitals do not choose homes. Hospitals cannot require a specific number of homes on lists, and they cannot require homes from specific lists or short lists. Again, we recommend that you deal with the HCCSS person in the hospital if you are there when making choices and all of that, because information from the hospital is problematic. So when you're consenting, so in order to give informed consent to your admission or to your choices, it has to, the information that's being provided has to be relating to the admission. It must be informed. That means you have to understand all the information. It must be given voluntarily, so not through threats, and not obtained through misrepresentation or fraud. So if you are told you must choose Shady Acres as one of your choices, that is a misrepresentation, untrue, and that consent to that home would not be valid. So there's certainly information that they have to provide when getting informed consent. So what the admission entails, expected advantages and disadvantages of an admission, alternatives, and the consequences of not being admitted. And also they have to provide you with information about that, about your admission or about the homes or whatever. So you can ask questions and they have to provide you with the answers to those questions. So who consents? So if the person is capable, only they can consent. And that's even if they have a power of attorney. We certainly see cases where people will have powers of attorney for personal care and the family member believes that they get to consent or make the decisions. And that is not the case. It's only if that person is incapable that someone else makes the decision on their behalf. Further, sometimes we get people saying, I don't want to make the decision. I want my son or my daughter to make the decision for me. Again, if they are mentally capable, they must be the person making the decision. However, you know, they are within their rights to make a decision in any way they want. As a capable person, so they can say, well, okay, you know, son, tell me what to do, and he says do this, and she says, okay, I'm going to do that. They certainly can do that, but it actually has to be that person who's actually doing the final consent. If they're found incapable, the person must be found, be provided with rights advice, and the capacity is determined as part of the process by the placement coordinator, and they have to be told that they're been found incapable, and they have a right to challenge that finding at the consent and capacity board. So if someone, for example, this is usually someone is made incapable and they don't want to go to long-term care, they would apply to the consent and capacity board saying, I think I am capable of making my decision. And there would be an application to the board, and those are heard very quickly. They're done virtually, of course, now. And the hearings have to take place within a week. Unless you agree to longer periods of time. Decisions are made within a day. And so those are fairly quick processes that can happen. And the person certainly is entitled to have legal counsel. And it's up to the evaluator, which is usually the placement coordinator, to prove that that person is incapable. The person themselves has nothing to prove. If they're found incapable and they don't challenge, or they challenge and they lose, then the substitute decision maker makes the decision on their behalf. And the Healthcare Consent Act sets out who the substitute decision makers are in the Act, in Section 20, and sets out what the requirements of that person are. So it's basically a guardian of the person, then an attorney for power, under a power of attorney for personal care. People can apply to the board if there's to be made the decision maker, as long as there's no guardian or attorney. They can't override that. But other than that, anybody can apply, and it doesn't have to be a family member. It could be a friend. Can apply to the board to be appointed the person's substitute decision maker. It's called a representative. That person also has to meet some other requirements, such as being capable themselves. So, for example, and then there's a hierarchy of family members, and then you have the public guardian trustee at the bottom who makes decisions for someone who has no one. For example, the substitute has to be mentally capable themselves. So normally a spouse would be your decision maker if you're incapable. That would be the highest on the list. But if that spouse is also incapable, then they would go to the next person, and it's not a formal capacity assessment. They just go to the next person. There are rules about how a substitute decision maker has to make their decision. So if there's a known wish, they must comply with that. And that can be very difficult when, for example, someone says, I never, ever, ever want to go to a long-term care home, and they have to determine whether or not that wish applies to the situation. It may be that I only want to go to a certain home, and again, you have to determine whether or not that applies to the situation. And if there is no known wishes, then you go into the best interest test, and that is set out in the Act as to what you have to determine. If the placement coordinator believes that the substitute is not making a decision in compliance with those sections, so they're not either complying with the known wish or they're not acting in the person's best interest, they can actually bring the person to the Consent Capacity Board, what's called a Form G application, and make a case that the substitute decision maker, is not making a decision in accordance with the law. So if you're making a decision and you're a substitute, you're going to have to be able to justify the position that you're taking, and because there's always the possibility that you could be brought to the board. So during the pandemic, as I said, there is an exception around the choices. So where there's a severe pressure on the hospital due to the COVID-19 pandemic, a placement coordinator can select homes for the person, even if that person's already selected homes. And the placement coordinator has to take into consideration the person's condition and circumstances, their preferences, including proximity to family, home, and community sports, and the class of accommodation. So whether they want basic, semi-private, or private. So once homes have been chosen, then the placement coordinator will send the applications to the home, and the home must provide a response within 5 business days with either, and the home can either accept or refuse the application, or they can request further information. So they can come back to the LIN and say, there's some behaviors here. Can you please advise us about those behaviors? We need some more information to determine whether it's something that we're able to provide care to. And then once that information is provided, then they have 3 business days after that to accept or refuse. There's only 2 reasons that a home can refuse an application. One is that the home lacks the physical facilities necessary to meet the applicant's care requirements. A common one would be someone who's in a very large wheelchair not being able to get through a door. There's certainly human rights issues around this, and whether or not they have to accommodate. The Long-Term Care Home Act doesn't speak to that, but certainly the Human Rights Code certainly applies to long-term care homes. So if you're being refused on some kind of a reason like that, you may want to, see if they can accommodate it and whether that's appropriate. Certainly things like large wheelchairs, I've certainly had homes refuse because they say that they won't fit in the doors, and we've gone and checked, and in fact they did fit through the doors. So, you know, that's something you should be aware of. The other reason is that staff of the home lack the nursing expertise necessary to meet the applicant's care requirements. So it's expertise. And it's also the ability to get that. So, you know, can they be trained? So if you have a certain disease that they're not familiar with, can they be trained on that? Things that are not reasons for refusals are high levels of care. So they can't say your care is too high for us. And this is a real conundrum, because I really believe that there's lots of people who do have levels of care that are way too high for long-term care homes. And the problem is that there are very few places that they will be able to get those that care because of the closure of chronic care and complex continuing care beds. So if you believe that the home shouldn't be providing care, or that there's an issue around high levels of care, that's something you may want to seek legal advice about. Staffing ratios in a home is not a reason. Age, as long as you're over 18, we can certainly just, you know, argue that, you know, 25-year-olds should not be admitted to long-term care homes, but they're entitled to. But I've certainly seen many refusals that have said, well, this person is too young, and, you know, we really don't, you know, our clientele is much older, and so we're not going to accept them. That is not a valid reason. Disability or illness. So, oh, you have X, Y, and you know, we haven't dealt with that before. So is it something they can be trained on? Can they, you know, an organization like a Huntington Society or Parkinson's or something be brought into the home to provide that training? That they have enough of that type of residents. So we already have 5 people who are being tube fed, so we don't want any more. That's not a reason. Use of an electric wheelchair, or scooter, or other device, unless it's specifically prohibited under the Long-Term Care Homes Act, and those usually have to do with things like restraints. But we certainly get people who get refused because they are using an electric wheelchair or scooter. That is a human rights violation, but we certainly have homes that do say that, and that is not a reason for refusal. Behaviors. Oh, that person has too many behaviors. Again, if they're eligible for long-term care, that means that a home should be able to provide that care. And so that's something that you would want to question. And another one that we see sometimes is the refusal of medication or treatment. So the person's going to be admitted, but they're saying, I'm not going to take a certain kind of medication or treatment. They cannot be refused on that basis. So in general, and again, there's some pandemic issues, but in general, when a person is refused by the home has to provide a letter to the applicant and the placement coordinator, setting out the grounds for withholding. So is it on, you know, is it the physical facility, or the nursing expertise? The explanation of the facts as they relate to both the home and the applicant's condition, and the requirements for care as to why they're not taking the person, how those facts support their position, and contact information for the director at the Ministry of Long-Term Care, because you can make a complaint on this. Now, during the pandemic, for whatever reason, the home no longer has to provide the letter to the actual person. They only have to provide it to the placement coordinator. But you can get the copy of that letter from the placement coordinator. It's still required to provide all that information. So even during, you know, pre-pandemic, people often did not get copies of the refusal letter. I have never seen a letter on first attempt that met the requirements of the law. So that's a big issue. They almost never have the required level of detail. And we found that sometimes the letter that was sent to the applicant and sent to the placement coordinator were different, and that shouldn't be happening. It should be the same letter. So if you are refused and you want to challenge that, first of all, your placement coordinator can go back to the home. There is a process that they have, and so you should discuss this with your placement coordinator and see if they have followed up with the home. As I said, if you haven't received a copy, you can get a copy from your placement coordinator. And then you can make a complaint to through the long-term care action line about that refusal, because that's something that the ministry can inspect on, and they will send an inspector. And this is not a fast process. It can take quite some period of time. And you would have to provide them with the reason that you think they have not properly refused the application. If the ministry does find that the home is non-compliant, they can issue an order. We used to find that they always did. It doesn't happen always now. It depends. But they will usually either they're going to either say that they should be accepting the resident or provide a valid reason for the refusal. So that's what they're going to tell them, is to either accept or provide a reason. It's very rare for the ministry to actually order a home to admit a person. That is very unusual. It occasionally occurs, but that would be very unusual. So these are examples of refusals. So we regret to inform you that we must decline your application for our waiting list because we cannot safely manage care for you at the time. Should circumstances change in the future, we would be happy to reconsider your application, blah, blah, blah. So, I mean, this is not clearly doesn't meet any of those requirements, isn't telling you why they're not going to accept you. So we don't know if it has to do with nursing expertise or the physical facilities. It's not giving any details. So this is clearly, this is a very common kind of thing we see, but clearly doesn't meet the requirements. Here's another one. We've received your application for admission to our home. Our admission review team has considered the application, and unfortunately we're not able to meet your needs. If your circumstances change, you can apply. Very generic, very general things. Sometimes what we get is, a tick box. It says, nursing expertise, and that's it. So again, it has to be detailed. It has to provide information about which of those two things that they're choosing, with the details, and moving forward from that. Now, once you've applied and you've been accepted, you will very likely be put on a waiting list. So most homes have waiting lists, which can range from a few days or weeks to many, many years. And can only be put on a waiting list if there's a valid consent, unless it's that special crisis. Various categories in waiting lists include crisis admissions, which are called category 1, spousal admissions, what they call former specialized unit and high acuity priority access bed residents have a special category. Ethnic, religious, and linguistic have their own category. So that's if you are applying to a home, for example, that provides services in a certain linguistic and has been designated. If you are of that, if you've identified yourself as being of that linguistic group, you would get in that category 3. And then other is just sort of your other general. The A's, so a 3A or 4A, are usually people who require care now. 3Bs are usually they're not very used. They can be used for spouses applying to long-term care where the spouse doesn't really need long-term care, because spouses actually can apply to long-term care and be eligible just by having a spouse in long-term care, as long as they're over 18 and have OHIP. But of course, they're in the very lowest category and would not likely be placed. We also have some special categories for veterans beds, a readmission, and that's a higher category than crisis. And those are people who've been discharged because they've been out of the home in hospital longer than the 30 or 60 days allowed. They would lose their bed, but then when they were ready to come back, they would reapply. And if they're accepted, they would go into this readmission category so that they would be reapplied to what was their home quite quickly. We have something called reunification priority access beds, and those are fairly new. Each home is to have 2 designated beds of this type. And it's where there's a spouse in a home and their spouse requires long-term care, and they're also a crisis. And so those are very high, and they would be higher than the regular crisis list. They were having direct access beds, which was a pilot project for specialized beds for alternative level care patients, so hospital patients. That's changed a bit during pandemic because of different rules that have happened. There's exchange categories where if you're in home A and someone's in home B and you each want to be in the other homes can exchange, and the same with hospitals. Not used very much, but it is available. We get a lot of questions about crisis lists. So crisis lists, which is the category 1, how you are on a crisis list is determined by the placement coordinator. They have rules within their organization that determines who's going to be on a crisis list. The list is by need and by date. So everybody who has sort of the same need. So let's say everybody in a hospital right now is a crisis. But they would go in by date because they are all the same. Someone in the community whose house burnt down would be a higher need because they were homeless and had these issues. So they might be in a higher, they might jump ahead of people who've been on the list for a longer time. Many homes, and I would suggest most homes at the moment, are only admitting from crisis lists, which is going to be for the foreseeable future. It may be mostly people from hospital because of pandemic pressures, but of course, people in the community are also put on crisis lists. Issues around crisis lists. So sometimes people are told that they have to have a certain number of homes on a list to be eligible for crisis. That is not true. The crisis is determined by the person, not by how many homes they have on a list. Applicants often agree to return from hospital to their home or other community housing, such as a retirement home. On the promise, they'll be put on a crisis list. And you have to determine whether or not that will compromise care. So if you're going into a retirement home, can it actually meet your needs? And doing that really does put further pressure on the health system because it takes away from home care from other people. Ongoing redevelopment of older homes will likely create further pressure on these lists, especially, for example, in places like the city of Toronto, where a lot of beds have to be redeveloped, but there's no planning where to put the people who are presently living in the home, let alone new people. So there's going to be even more issues around crisis lists in the future. So bed offers. So bed offers are made by the HCCSS. So we've got a call. It will be for a bed that's on your list, whether you put it there or, if you're in a hospital, if the placement coordinator, although we don't see that much, they could potentially do that. You have up to 24 hours to decide whether or not you're going to accept the bed. If you accept the bed but aren't ready to move, say you're living in a retirement home and you have to, pack things up or wait for your child to come and help you, things like that, you can pay for up to 5 days to hold the bed, but you must move in before noon on the 5th day. Even if you don't move in, you have to pay for those 5 days. If you refuse a bed offer, so if the bed offer comes in and for whatever reason you refuse that bed offer, if you're in the community, you will be taken off of all waiting lists. For 12 weeks, you have to reapply and start all over again and go to the bottom of the lists. If you're in hospital, you won't be removed from the lists, but you may be discharged or charged an uninsured rate, which can be thousands of dollars. And remember that you could be offered a bed that you haven't, quote, chosen because it was chosen by placement coordinator if you were in hospital because of this, special pandemic rule. And so if you were offered that bed and turned down, the hospital, that would be seen as a refusal of a proper offer. And so these things could happen if you were in the hospital. Lots of hospital discharge issues, so requiring certain numbers of homes from short choice lists, requiring you to accept or apply to available beds. We often hear people being prevented from applying to long-term care, so being told that they have to, they're not allowed to apply from hospital, told that they have to go home or a retirement home to wait. Saying if you don't choose off of our short list, we're going to charge you thousands of dollars a day. Prohibiting you from making applications or telling you they have to go to the management to allow that. requiring your family to take you home and to take care of you, or requiring you to go to private healthcare, retirement home, or transitional care. Under the Public Hospitals Act, and you'll hear this, is that the doctors have to discharge you within 24 hours when you don't need acute care. However, if you need long-term care, they can't abandon you. They can't return you to home with supports, if that's not appropriate. And a person can, if they're waiting for long-term care, so you've applied and been made eligible, you can stay in hospital pending transfer. They can move you around in the hospital to, the reactivation units, things like that, alternate sites. You will be called alternate level of care. But that's why they don't want you to apply, because they don't want to long-term care from hospital, because if you are eligible, you do have an argument that you can stay because you need to go from one healthcare facility to another. You don't have to share your choice list with the hospital. They are generally shared, but you can ask to have those choices put in a lockbox so they don't know what homes you've shared. And that would be done through the placement coordinator. We don't hear so much about the home first philosophy anymore, but this is to go home and wait for long-term care at home. It's a philosophy, not a program. You hear, a lot about people wanting to wait at home, or, it's much better. And again, it's up to you to decide whether or not it's appropriate for you. Certainly there are many benefits to being at home in the community. In certain cases, that home first, there may be a carrot, they may provide more care, but they also may provide, tell you you're going to get care and then pull it back, or, people don't show up. So you have to decide whether that suits your situation. And again, we often suggest people get things in writing about what it is that the placement coordinator is promising in the home first program, so that, if there's any problems, that you can go back to them and say, no, that's not what was promised. So you can't send someone home and say, well, now that you're home, now you have to choose off the short list because we're going to remove all the services. So that's one of the issues that we see. We certainly see them say, well, we'll only, after someone's home for a few days, they say, okay, well, now we've decided, we did promise you 12 hours a day, but we're going to pull it back to 6. And we see that happen. They can't have inappropriate requirements for eligibility of those of that services. And it does reduce care from other people, because if they're topping up all these people coming out of hospital, then those who are coming into the community or who are living in the community and require services often can't get home care because it's a limited resource. We see the use of retirement homes as alternatives to the long-term care homes. You have to remember, retirement homes are tenancies, they're not health facilities. So people are told, you should go into a retirement home to wait. For many people, that may be appropriate. It might be much better, but they are private pay. They're regulated differently, and they're not part of our healthcare systems. And there has been some criticism of the use of retirement homes because they are not long-term care homes. They are not private long-term care homes. They are tenancies. You're a landlord, and then you purchase the care. So you have to make sure that, is this a proper alternative for you? We've seen the use of unlicensed residential care. These may be places that aren't able to get a license or don't want to get a license. Maybe some other kind of a facility. We've seen, places like In Touch would take people, Comfort Residential Group Homes, Drew's Residential Services. Those were unlicensed group homes. And people were referred through hospitals to those facilities. And that's because they want to, sort of get anyone out, no matter what. And so, we certainly see that. So if you're being told to go somewhere else, you need to do your homework as to what kind of a facility is it? What is the oversight? Is it an appropriate facility? Does it have a history? Why doesn't it have a license, for example, as a retirement home? We see a lot of transitional care programs these days. These are usually housed in a retirement home or other kind of residential care setting, and are providing care for discharged hospital patients waiting for long-term care. The care may be through the hospital or through home care. but the arrangements may be made for these transitional programs. They may be set up through the hospital or through HCCSS may have these programs set up. The issue is that settings and available services may not be appropriate or sufficient. You may be told that these are mandatory programs, which is not true. Even if it's located within a retirement home, because those beds have government funding, so the funding comes through the government somehow, even though it might be flowed through a hospital, for example. Once that happens, it is no longer covered by the Retirement Homes Act and the Retirement Home Regulatory Authority. So that oversight that you would get through the Retirement Home Regulatory Authority is not available. And so there may be no oversight in the homes, and many of these transitional care homes have no oversight at all. And that, of course, is a big concern to us that we have brought up to the ministries, but that has not been resolved. And so if you have a problem with it, you can't go to there's no ministry to go to, there's no ombudsman to go to, there's no authority to go to. You're sort of stuck in the mercy of the home. So what kind of ALC issues do we run into? So people are made ALC, which is alternative level of care, while waiting to go to another destination. ALC does not mean a charge. It does not mean going to long-term care. It just means you're waiting for somewhere else. So it could be to going back home because you're having some, a ramp built to go into your home. It could be going to complex care, retirement home, etc. Many times these people are referred to as bed blockers. It's usually people who are waiting to go to long-term care who are called bed blockers because they are seen as taking up a spot in the system that they're not entitled to. Of course, it's a systemic problem. It is not the person's fault that there's no beds to go to in long-term care, for example. There may be costs associated with the designation in very specific circumstances. So as I said, ALC designation does not mean a copayment, and you can only be charged the copayment if it meets certain requirements set out in the Health Insurance Act. So I've sort of simplified it very much for this. It's more complex, but generally the doctor will have to designate the person as either being chronic care or requiring permanent care, basically that you're waiting to go to long-term care. Only certain hospitals set out in the regulations are allowed to charge copayment. So not all hospitals are entitled to charge a copayment. Just because you're in a chronic care bed does not mean that they can charge you. So chronic care patients, if you're in a chronic care permanently, a permanently resident in chronic care, you could be charged in most circumstances. You still have to meet a bunch of criteria. But what we're seeing is those chronic care beds being changed into slow stream rehab, but person may be still charged because the hospital says, well, it's a chronic care bed. If it's rehab, you cannot be charged. So it doesn't matter what the bed is designated by the hospital. It has to do with the patient, whether or not you can be charged. And if you were admitted at all during your hospitalization as a Mental Health Act patient, so came in on a Form 1, we're on a psychiatric unit, we're detained under the Mental Health Act, even if you are now alternative level of care and you're finished that mental health portion, once you're in the hospital as a mental health patient, you continue as a mental health patient until discharged. You cannot be, in our opinion, cannot be discharged as a mental health patient during that time in hospital. So it's as long as it's a continual hospitalization, if the Mental Health Act is used at all, then you're a Mental Health Act patient, you cannot be charged. There are maximum rates. Currently, it's $18.91.31 a month. There are rate reductions available, and we do see a lot of problems around rate reductions in hospitals. We do see that there are problems if you're anything outside of, on the regular pensions with these rate reductions, and there's little to no oversight on the charges on these rate reductions or on these rates at all, even though they're under the Health Insurance Act. No one ever checks to see if hospitals are charging them properly, and we find problems all the time. It's only based on taxable income while you're in hospital, so the ALC patient copayment or the chronic care copayment is only on taxable income. So if you're getting guaranteed income supplement. It cannot be used to calculate the rate reduction. They would only use your old age security and other taxable income. So that's really important to know. Other issues that we run into are hospitals telling persons that they're not going to charge, that they're going to, not telling them that they're going to charge the copayment and then backdating. So maybe you've been an ALC patient for 2 months and then they say, oh, well, we're backdating it now to, September because you've been here that long. They can't do that. Yes, the law says that they're entitled to charge the copayment and they don't have to have your consent, but they can't simply backdate because they didn't tell you at the beginning. We also see it sometimes where they try to backdate it when they feel that you haven't been cooperating in the process. And so they will try to charge you back. So where they, for example, we see hospitals have said, been trying to prevent someone from applying for long-term care for a couple of months. And then when they actually do apply and get eligible, then they try to backdate it. And they can't do that. We also want to warn people that if you have semi-private or private coverage for a hospital bed and you're admitted for your acute care, you would have coverage for semi-private or private. However, once you become ALC, insurance companies, I've never found an insurance company that will pay for that. And so you have to make sure that if you are being made ALC, unless you want to pay that semi-private or private coverage, which could be hundreds of dollars a day, you are asked to be moved into basic and that you withdraw any consent to being in semi-private or private because you will be charged by the hospital and your insurance will not cover it. So I've gone a little bit over, but I've left about 20 minutes or so for questions. So thank you very much. And I'm open to questions.
Thank you, Jane. That was so informative. And we have a couple of very interesting questions here. The first one is around the long-term care admission process. You had mentioned that no one can be required to care for an adult if they do not wish to provide that care. Can you comment on our responsibility under Section 215 of the Criminal Code, which requires an adult child to supply a dependent parent with the necessities of life in certain circumstances?
Sure. So if that's exactly right. So if you have that person in your home or you're assisting them in living in the community potentially, but mostly if it's in your home, you would be required to provide the necessaries of life. And if you are not able to do that, that would be a reason to say to the hospital, look, not only can I not do it, but if I take them home and I can't provide that care and they get ill or something happens to them, I could be charged criminally. And so it's only when they're under your authority in the community that would happen. So that's, often something we talk to people about is saying, if they say, I can't move them, I can't do this, I can't prevent them from getting into harm, that would be a really good reason to say to the hospital, I cannot provide that. If they're in the community and you can't provide that, that's a discussion that you're going to have with your placement coordinator saying, look, I can be charged criminally. I need to get them out of here now. This has to be a crisis because I can no longer provide the care necessary. And, it's going to be a criminal offense if I don't provide that care. So you need to assist me and get them either the help in the home or get into long-term care.
Thank you. If an incapable adult or parent's prior wishes is not to ever go into a long-term care home, can a power of attorney or substitute decision maker still apply for them to be admitted into long-term care?
So yeah, that's obviously something that happens. And so this has came before the Consent and Capacity Board many years ago, this issue. And what the Consent Capacity Board said was that until the person's finances are drained, it is still possible to keep them in the community. So what the Healthcare Consent Act says is that you have to comply with the wish unless it's impossible to follow. So, I think that pretty much it's been accepted, although it's never been litigated, and I think it could be, but it's been accepted that if the person said, I don't ever want to go, but there is no longer an ability to care for that person, so there's no longer the resources and the ability to care for the person in the community, then it becomes a wish that you cannot comply with. But until such time as you've, put a mortgage on the home and used all that money up, or reverse mortgage or whatever, and used up all their assets, you may be stuck having to provide that care out of their remaining assets until such time as those are no longer available. And then you could say that it's a wish that you can't comply with and would have to go with their best interest.
Okay, thank you. There's a bit of a scenario here. So if a senior is in a long-term care and the family is participating in their care, however, the public guardian and trustee is the guardian by court decision, have you seen a circumstance in which the family regains their status as substitute decision makers without a legal battle?
If there's a court order, so I'm not going to get into too much legal advice. This is obviously a very specific legal situation, and really not what we're talking about today. But no, the court, it would require a court order. So it would require going to court to return it. If it's a court order, you can't, there's no other way other than getting it changed through the courts.
If there are issues with the discharge planner, and I'm assuming discharge planner in the hospital, where should that person be going if they feel that there are issues with the discharge planner?
So there's a couple of things. So it sort of depends on what the issues are, right? So if the discharge planner is, if it's around the issue of the application for long-term care, you should be dealing directly with the placement coordinator from the hospital and not the discharge planner. So just don't even discuss placement with them. Say, I'm just going to do this through the placement coordinator and not through the discharge planner. So that's one of the things that we tell people. So it's usually around the discharge planner telling you can't do this or that. If there's issues, you can certainly go to the patient ombudsman or patient relations in the hospital. If there's a complaint, and it depends on what your complaint is it that they're not very good at their job and you don't like them and they're mean, you can certainly go to their boss, but usually it's around the information and what they're trying to push. So you can go to the patient representative in the hospital, and if they're not helpful, you can then go to the patient ombudsman of Ontario with respect to issues like that. But in general, what we usually find is that if they can go to the if it's a discharge issue, or if it's trying to get applications for long-term care, go directly to the placement coordinator.
Thank you. Would you please clarify the role of a substitute decision maker or attorney when applying for long-term care on behalf of an incapable parent or adult?
So the substitute decision maker becomes makes any of the decisions that are required. So they would be stepping into the shoes of the person, so they can make the applications, they can choose the homes, they can deal with the hospital, they're entitled to information, they're entitled to records. So if they need to get documents, they're certainly entitled to that. And then they have to comply with the Healthcare Consent Act and the Long-Term Care Homes Act when they're making the decision. So, whoever's getting, the placement coordinator, they have to get informed consent from the substitute decision maker. And that substitute decision maker has to comply with the law when it's making its decision. So they have to either comply with a known wish or make a decision in the best interest test. And that might include talking to the incapable person. Just because they're incapable doesn't mean that they don't have an opinion. It doesn't mean you have to comply with it, but you have to take it into consideration. Is the admission going to be better? Keep them healthier, safer, etc. So there's a whole list of things that they have to do. But they basically step into the shoes with respect to that placement decision.
And a bit of a follow-up here. If a substitute decision maker is not complying with legal requirements when making a decision about admission to long-term care, what type of order
Okay, so what would happen in those, you've frozen, Molly, so at least on my computer you have. So what happens is it's up to the placement coordinator if they believe that the substitute decision maker is not making a decision in compliance with the legislation. The placement coordinator would go to bring a Form G application to the Consent Capacity Board. They would make a case as to why they weren't complying. So let's say what would be a common situation would be the substitute wants to bring them home and take care of the person at home. Maybe, for example, the child, it's a child, like it's a daughter, and mom is living with her, and she doesn't want mom to go to long-term care because she's using mom's money to pay the mortgage at her home. And so she's making a decision because she wants mom in the home, not because she wants to provide the services, but because she wants mom's money to pay her mortgage. The placement coordinator would have to show that she's, making a decision not on mom's best interest, but on her own interest. She's doing it for monetary reasons, etc. And then the board would order the substitute decision maker to consent to the admission. And if she refused, then it would go to the next person on the list or the public guardian and trustee.
Thank you, Jade.